fear in our community as a result of the misinformed workshops is that the PLDC is going to be selling our ceded lands. Well, if you look at the materials, you'll see that there was a law passed allowing the sale of the ceded lands. But it wasn't Act 55, the PLDC law. It was Act 176. It passed in 2009. Why? Why did that happen? It happened because Professor John Osorio teamed up with some OHA trustees, and they brought a court case, OHA versus HFDC. And in the court case, they said, because the U.S. Congress apologized for overthrowing the kingdom, that means the state can't sell ceded lands. Well, the argument got as far as the U.S. Supreme Court, and then it was struck down. The U.S. Supreme Court ruled that the state could sell ceded lands. And that was in 2008, and the following year, in 2009, Act 176 was passed into law to allow the sales of our ceded land trust asset, Hawaiian and public alike. And since that time, there has been sales of the ceded land. I opposed it. I opposed it. Many of us did, but we lost it. So if we're going to stop the sale of the ceded lands, then we must repeal Act 176 that resulted from the OHA litigation. I'm in the process of writing an article responding to John Osorio. How dare he call for the repeal of the PLDC because he was a plaintiff in the OHA case versus HFDC. He is the one who lost it, and he is the one who got the state legislature to pass the law. Prior to the U.S. Supreme Court ruling, no one would have tried to sell ceded lands. But after that case, they sure have been selling ceded lands. What I'd like to see is I'd like to see the PLDC rules and their strategic plan amended further so that we can ensure that there are more protections. I'm happy that the civic clubs passed resolution, which Anel will present following. They didn't go along with the environmentalists saying, let's repeal. Nobody went along. You know what nobody's telling you? The law passed in 2011. It hasn't gone anywhere. There hasn't been any single project. It's still in the rule-making process. So now is the time to address the concern instead of running away and calling for repeal. And finally, this.
With regards to Act 176, which authorizes, so what happened in the Office of Hawaiian Affairs was involved in litigation that went up to the U.S. Supreme Court. The U.S. Supreme Court didn't say that the state can sell ceded lands. The U.S. Supreme Court said that the Hawaii Supreme Court is not allowed to rely upon the apology bill to conclude that the state cannot sell ceded lands. And so the Office of Hawaiian Affairs, in settlement of that litigation after it came down here, afraid of it going back to the U.S. Supreme Court because we know that they're not friendly to Native peoples, settled the litigation. As a result, the legislature passed Act 176, and the Office of Hawaiian Affairs was a part of that, and that was a part of them settling their lawsuit. So Act 176 doesn't, yes, it gives permission for them to sell, but the difference and critical difference is that the legislature has to approve of any sale, and the Office of Hawaiian Affairs and the public gets an opportunity and information beforehand, well beforehand, so we can do our due diligence and determine whether or not those lands are ceded. So I just wanted to share that with everybody.